Welcome to another podcast of the Patriotic Pulpit. I am Bill Lockwood. Today we're talking about judicial tyranny. Many people call it judicial supremacy, but it is really tyranny that we're under as American citizens by the judicial branch of the government, specifically federal judges, of which there are more than 1,700 sitting on federal benches, numbering over 200 in the United States, and they are absolutely blockading what the American people have wanted with Donald Trump. President Trump has signed more than 80 executive orders, according to reports just the other day. It probably is over 100 at this point. But that has at the same time prompted over 100 lawsuits lodged in federal courts against Donald Trump's executive authority. Now, so interesting and ironic that Democratic lawmakers have accused the Trump administration of launching a constitutional crisis in America. But just as everything that they touch and everything that they say is the opposite of the truth, and that is the Democrats are actually the ones launching the constitutional crisis in the United States by reverting to the judicial branch to overturn the executive branch and his duly constituted authority. That's absolutely stunning to me, and I take the position, just as Andrew Jackson did. He said that's the judicial branch, or that's the federal judge's opinion. Now let them enforce it. It is absolutely outlandish that the judicial branch or federal judges should overturn the will of the United States people. But let's dig into it just a little bit more. Number one, judicial supremacy is a radical overextension, indeed a perversion of the legitimate doctrine of judicial review and stare decisis, that is to stand by matters that have been settled. Judicial review posits simply that the Supreme Court has the authority and as a practical matter often must construe the Constitution in the course of deciding what the Constitution describes as cases and controversies that come before the court. An opinion of the Supreme Court on a constitutional issue ascertains and applies the meaning of the Constitution on that particular point of law under the peculiar facts of that case, of that controversy, as against the actual parties that are then before the court. But generally, it is not to affect anyone else. In other words, it is to apply to the parties before the court. Not only so, but judicial review tells us that the court should remain consistent. Stare decisis is merely judicial policy that the courts, in order to promote predictability, stability in the law, should abide by the previous decisions in future cases that raise the self-same legal issues under substantially equivalent sets of facts. That's really the idea of judicial review. But judicial supremacy is a radical extension, overextension of that, by not only applying it to the persons or the persons that come before the court, but also making it extensive to everyone in the country. That's what's taking place in America. Judicial supremacy then claims that an opinion of the Supreme Court determines and fixes the meaning of the Constitution as to not only the issue under dispute, not simply as against the actual parties that are before the court with respect to the specific facts of their case, but in principle as against anyone and everyone in the world similarly situated in all imaginable cases. In particular, as against Congress, as against the president, as we're seeing right now, against Donald Trump, against the states, even against we the people. And that's exactly what we're seeing taking place in America right now. And that is upon its mere opinion, the mere opinion of the court. The opinion of the court becomes the supreme law of the land on any point of law which everyone else everywhere is required to accept and to follow. That is not what our founding fathers intended. I don't think anybody can actually argue that that's what they intended. Think about how judicial decisions become the supreme law of the land. It's fascinating to look back, sad to look back and how this is played out in America. Think about how Obamacare came into being. But how judicial decisions, the opinions of a court, have become the supreme law of the land. Judicial supremacy asserts, number one, in a point of constitutional law decided in an opinion of the Supreme Court can only be overruled or otherwise modified by what? Only a later opinion of the same Supreme Court or a formal amendment to the Constitution. What is that to say? That is to say that the Supreme Court asserts to itself that it is the final court of appeals for law for everyone in this country, not simply for matters and the parties that come before the court, but for everybody in the country. We'll see in just a moment how that cannot possibly be the case. So the supreme law of the land, that's how judicial supremacy thinks about it. Number two, they tell us that nothing ought to or even can be done by justices of the Supreme Court, individually or collectively, as a consequence of any opinion they hand down on any issue of constitutional law, no matter how obviously erroneous, politically motivated, economically or socially destructive, or even knowingly, willfully false or fraudulent may be. Thus, under judicial supremacy, the Supreme Court perverts judicial review and stare decisis into mechanisms for supervising, revising, reversing, precluding the acts of all other branches of government, including the states, all of the subdivisions, the general government, we the people, and the President of the United States. So writes Edward Vieira in The New American, 2009. Let's think about these things for just a moment. There are several points that I want to make regarding it. Number one, judicial supremacy, judicial tyranny contradicts the Declaration of Independence. The Declaration of Independence posits itself on the popular sovereignty of the people, that governments instituted among men, deriving their powers from the consent of the governed, which mandates a government of the people, by the people, and for the people. That's how Abraham Lincoln put it. Not arbitrary rule by judicial or any other elitist, responsible to no one but themselves. What does the Declaration of Independence therefore mean by that? That is to say that the people have actually given to the federal government some of our authority. We have authority, we have right, and we give the federal government some of those rights. That's the idea. It is not that this Supreme Court or a federal court system has the supreme authority over Americans. That is not how the Constitution was set up. The Constitution's preamble even says this: we the people, not we the judges, we the people do ordain and establish the Constitution for the United States of America. Now this is interesting that the Supreme Court itself recognized the power to enact carries with it final authority to declare the meaning of legislation. That was in Proper versus Clark in 1949. Sir William Blackstone, the Founding Fathers' legal mentor, emphasized that whenever a question arises between society at large and any magistrate vested with powers originally delegated by that society, it must be decided by the voice of what? Not the judges, but the people itself. There is not, he writes, upon earth any other tribunal to resort to. Commentaries on the Law of England, 1771. So the point simply is this: that judicial supremacy overturns the Declaration of Independence, because the Declaration's primary principle is, and by the way, it is a foundational law of America, that the people have popular sovereignty. We the people, not we the judges. Number two, judicial supremacy nonsensically assumes that the meaning of the Constitution's provisions are, number one, largely unknown or even unknowable unless some kind of special black-robed judge stands up or sits down in front of us and tells us this is what this means. And everything becomes politically plastic in a kind of a living constitution. I want you to think about this for a moment. Each and every provision of the Constitution, 1788, and the Bill of Rights in 1791 had to have meanings that were known to, or at least knowable by, the people who ratified those at the time. Who ratified the Constitution? Who agreed to the Declaration of Independence? It was we the people. As a matter of fact, we the people agreed to the Constitution before there was ever organized a court system. How could that possibly be if, in fact, it is the case that we can't know the meaning of the Constitution outside of what the Supreme Court tells us is the case, or a federal judge sitting down in Washington, D.C. tells us, well, President Trump has to turn the plane around, we have to take back all those illegals from Tren de Aragua. We have to take them back because that's what I say. This absolutely turns the Constitution on its head. The Constitution was passed, ratified, agreed to by the people of the United States way before there was ever a court. So, the meaning was not so vague, was it, at the time of ratification? At the time of ratification, the people understood it. So the very point that the idea or the concepts of the Constitution cannot be known by we the people before the Supreme Court steps in or a federal judge tells us what must be the case, that is absolutely absurd. And are we to be held hostage by the tyranny of the hundreds of liberal federal judges in this country, overturning the President of the United States, the chief executive of this country? Absolutely not. Here's something else interesting. Why is it the case, and how could it possibly be the case, that the federal law everybody can read regarding the border was left to the federal government to protect, and federal law tells us that people who are coming here out of country, foreigners, must come through legal processes? But the former president, Joe Biden, not only neglected, but thumbed his nose at that law, said, I'm going to violate it, and he violated it every single day. And very few federal judges ever stood up and said, hey, and we the people cried out and said, he is violating the law every single day. We can read it. We can understand it. And yet the liberals, they didn't file these injunctions. Now all of a sudden, when President Trump is exercising the right of the executive branch, doing exactly what the Constitution tells him he must do, federal judges are stepping in and saying, no, you can't do that. That to me, that shows you we have a system of tyranny, and it is a tyranny of federal judges. I want you to think about this also. The Supreme Court itself did not even exist when the Constitution was ratified. No judicial decisions interpreting the Bill of Rights. These were not extant. That is the first 10 amendments. They were all ratified by we the people. And how about this also? When we have federal officers that are sworn in to the Congress of the United States, they take oaths to uphold the Constitution, don't they? And yet, they take oaths to uphold the provisions of the Constitution. Many of those provisions have never been tried at all in a federal court. So is it the case that we can't know what they are? How are they swearing to uphold the Constitution if, in point of fact, we cannot know the Constitution until the Supreme Court speaks? That is absurd. We know what the Constitution means. We know what it was intended to mean, and we can read it for ourselves. And the federal judges are out of control to try to stop Donald Trump from doing his duly constituted authority and protect the borders of this country and getting out the illegals. What we have going on here is a revolution of the federal judges in black robes. That's what we have going on. And we need to stop it. We, the people, need to exercise the authority to interpret the Constitution, invoke the right to peaceably assemble, petition the government for a redress of grievances as individuals and ad hoc groups, as the First Amendment guarantees, and even greater. Remember that we have the right to keep and bear arms, and a federal judge has not a right to tell us, no, you can't have firearms, as many of them are trying to do. All of that is necessary for the security of the free state. But federal judges want to tell us, no, we'll tell you what this means. We think it means something different. No, we can read the Constitution for ourselves. Nothing could be more necessary to the security of a free state than people looking at the Constitution, understanding it, reading it, interpreting it for ourselves. The federal judges who are trying to overturn we the people, they need to be disbarred.